Hi, everyone. I hope this is working. It's Jody Katz. We're trying LinkedIn Live for the first time ever and learning as we go. I am the founder and creative director of Base Beauty Creative Agency. I'm also the host of the Where Brains Meet Beauty podcast. And if you've stuck with us through the technical difficulties, you're here to learn about beauty claims and the law. And I'm so happy to be joined by Steve Weigler. He's from EmergeCounsel. He's a good friend of Base Beauty, and he promised to make the law fun for us today. Hey, Steve.
Hey, good to see you, Jody. Are we ready to get started? Um,
I hope.
let's let's hop to the why listen. So again, my name is Steve Weigler. I do a lot of marketing and branding law in the cosmetics industry as well as in e-commerce. And I think when people are sitting down and saying, "Well, what am I going to do today?" Oh, there's a lawyer presentation. That it's not the first thing that people go jumping. At least that's how I would be. So I realize that this can get mundane and boring. So we're gonna make this fun in two ways. Number one is the subject matter really matters to you, and I'm gonna convince you that it really does. And number two is we're gonna have a contest, and we're gonna have five increasingly difficult questions, and you'll comment through comments. You'll answer the question and put your name, and then at the end we'll tally who got the most right answers, and we'll put you in a drawing for a bottle of Taittinger champagne is the first prize, and then the grand prize. And the next one, the next two runners up will get a box of sea suckers. Why did I pick those brands? Because those brands are iconic. I could have picked any champagne. It might be better. It might be cheaper for me to buy for you. But the point is these companies in other industries have established a brand, and that's iconic and sells for high and will definitely command value in the marketplace and in the business world. And that's what we want to make sure. If we could get to the next slide, that's what we want to make sure. The next PowerPoint, please. Thank you. That's what we want to make sure in your industry, that you're building the brands and building the marketing collateral and building the products that maximize value for your investors, shareholders, and members of your company. So and one thing that can kill in your industry and specifically is lawsuits that focus on marketing claims. And so why you and specifically is that your industry is huge. It's a $250 billion industry. Specific to the cosmetics industry, it's a highly regulated industry, and specific claims are if you make a claim that the FTC or the Food and Drug Administration might consider a drug claim, it's not the FDA or the FTC that you have to worry about. It's that plaintiffs' attorneys will pick up on those claims and sue in something called a class action. And that means that they just have to find one person that's been affected, and then they can certify it as an entire class. It means anyone that's ever used a product. Well, that can take a great brand, and we'll go through some of these examples of what's happening now, and make it what's called a toxic brand, or a brand that went from $200 million of revenue and huge name recognition to one that people run away from. And that is all a lot of times on the marketer or the brander's watch. And that's why we work together as attorneys and branders to make sure that that doesn't happen. So I think the important part today to learn, besides, hey, maybe I'll win a bottle of champagne, is that these claims are for real. It's happening a lot in your industry. It happens to big companies and small companies. The other one, the area we're seeing is in claims of being natural, and claims about the ingredients in the product. And then third is everyone sells into California, like it or not, and California has its own labeling. Proposition 65, where you have to label any potentially harmful chemicals, even though they might not be potentially harmful to you, or one that one would think about. Let's hop to the next slide. So I'm going to go through this really quickly. There's three laws when it comes to cosmetics in particular. There's the FD&C law, which I think some of you know, or is if you have a drug, it has to be cleared through testing established by the Food and Drug Administration. If you have a cosmetic, or it's considered a cosmetic, you do not have to do this, but you're responsible for certifying your own safety of the product you're launching. A lot of that goes into labeling, because if you label it as a drug, the FDA and, more importantly, plaintiffs' attorneys are going to consider it a drug. And it's a pretty complicated statute, so or regulation and statute. So you have to look at that one very carefully. The second one is the Fair Packaging and Labeling Act, which is what you put on the package. And like, for example, if you go and get a pack of Fritos, on the back of the Fritos or Doritos, they say first ingredient corn, etc. That's that law. And that's in cosmetics or in drug cosmetics, for lack of a better term. Also, you have to list the ingredients in order of what's in the ingredient, and you have to do that in a clear and obvious way. And there's certain regulations on how you do that. And then Proposition 65, you literally have to put, if, for example, you have a mineral product and it has trace lead, well, you have to put on the labeling that it's Prop 65 compliant and that there's lead. Otherwise, there's California bounty hunters out there that will sue on behalf of the government, and all these cases are really hard to get rid of. So let's go to the next slide. Next slide. Let's play. We're ready for the first question. Remember, type your name, type the answer. Let's play what's a drug and what's a cosmetic. So only one of these claims has not been challenged in a court as being a drug claim. Which one do you guys think it is? I'm going to give you 2 minutes or less to look at the claims and figure out which one hasn't been an issue subject of a lawsuit for labeling. All right.
This is a hard one, Steve.
We have a lot to go through. Go ahead. How is the comments coming? Is everyone typing it in?
You know what? I actually can't see the comments, Steve. I wonder if our producer, Carrie, can see them.
Carrie, any luck on that? All right. Well, if everyone could if you write down your name and your answer, and if you can't get it into the comments, we'll figure out a way to email it later on, so you can claim your prize. So let's take a look at what is a drug and what is a cosmetic. Next slide,
Steve,
please.
I have an answer for you, Steve. Wait, Robin's helping me out here from behind the scenes, and she's telling me that everybody answered C.
Well, let's go to the next slide. Everyone is right. Nourishes skin for a flawless complexion. However, there have been cases where claims of nourishment on cosmetics have been made and still resulted in a lawsuit of a drug. So it's very important. Nourish is much more innocuous than the words than the other claims. But at the same time, it still is not a free-for-all. So you guys were good at figuring out what is a cosmetics claim versus what is a drug claim. Let's go to round 2. Same question, 3 different ones. Causes longer, stronger hair growth and cell regeneration, instantly hydrates and adds shine, or helps to combat hair loss. Give a couple seconds.
So, Steve, you want our viewers to think about which claim has not been challenged in the courts.
Mm-hmm.
Wow, this is a hard one too. Okay, let's see. I think people are typing in their responses right now. And I know Robin's going to give me an assist from LinkedIn Live. Let's give them another moment.
Sure.
I'm going to tell you, before I tell you which one everyone else picked, I think that I'm going to pick B. And let's see. Oh, that's interesting. Many, many B's and 1 C.
Well, I think it is B. If we could go to the next one, it is B. But I think again, as to be a good industry attorney, you have to also think like a plaintiff's attorney. And I could see how I could, if it were me, I can attack this because hydration is becoming a huge um, drug buzzword. There's a lot of hydration products out there outside the industry, mostly in the supplements industry, that have been challenged for the hydration claims. So you have to, if the product itself is a hydrating product and really can perform that functionality, I think it's only a matter of time that a claim like B will be a drug claim. And A is and C is why they've been challenged is hair loss is a huge area. Baldness treatments have been claims of that we can cure your baldness or hair, thicken your hair have been going on since the turn of the 19th century, and so it's just one that the FDA, FTC are aware of, and so plaintiffs' attorneys are going to pick up on that. So I think all of these are subject, but Jody, you're absolutely right. So the next one. So you guys, now we're going to go into private causes of action. What that means is, again, sure, you're going to read some of these, and you can read it in industry publications. You can see it at Cosmoprof. There's going to be lots of lectures about, oh, here's what the FDA is going to do. Here's what the FDA is doing. Well, that's all like great, but at the same time, and great to know. But what you really need to be scared of and aware of is not so much that the FDA or FTC is going to come after you. It's that they establish precedent that plaintiffs' attorneys, and these guys or women are just trying to make a living. But the point is this creates the causes of action that they're going to go after. So when you see these kind of cases, what you're seeing is they're suing the product manufacturer or branding company for false advertising because you advertise something that is outside the FDA regulations on what you can advertise. That it's a toxic chemical that you put in and didn't label it. So it's called a toxic tort, that you knowingly or negligently put this chemical in there, that the practices are unfair to the consumers. And then there's a laundry list of, usually when an attorney files a lawsuit, there's a laundry list of claims and a laundry list of who they go after too. So it's not sometimes only the company, but sometimes it can be the branding and marketing company. Sometimes it can be the legal team that helped you on this labeling. And then each state, especially California, Colorado, and Nevada, have their own unfair, their very strong Consumer Protection Act claims. So you have, and especially California. So Proposition 65 is a consumer cause of action, and that has its own remedies, including that they have these nonprofits out there, and I put nonprofits in quotes, that go after legitimate companies and go after them for their claims and that they're not Proposition 65 compliant. And they really don't go away until you pay them off. So that's the next thing. So now we're going to do, to make the point clear, if we could go to the next slide, causes of action. So let's look at some. So I'm going to whip through this and show you what I mean. Cosmetics labeling. So these are claims specifically focused on the labeling. So Amplify made a claim that the product causes new hair growth and blocks the hormone DHT. It also claimed that the product reduced wrinkles and tightened skin. So not only do they need to relabel, which again, relabel's a form of rebrand a little bit, at least it's the beginnings of it, and the case costs Amplify in 2021, we're only focused on the modern cases, cost Amplify $3 million, is what I calculated. Now, sometimes you're going to say, well, it only cost them $150,000 of damages, because if someone used a product and it didn't grow hair, well, it's not necessarily gonna be break the bank for that particular plaintiff. The thing is, all these cases, the attorneys are looking for their attorney's costs, which run into the millions of dollars. So it's not so much that the consumer, and you guys have seen this if you like flew in airlines or something and you got a class action notice, you get like $3.50 spread around each person spread around the class. But it's the attorneys that are making these cases be very high because they get attorney's fees. So even smaller companies, so Amplify was a big case, even smaller companies, there's an Adore Organic innovations. And what they claimed is it was proven to restore youthful appearance by protecting your skin's own stem cells and encouraging them to regenerate healthy texture. In that case, settled for $558,000 in cash, but then the attorney's fees added up. Now, the point I want to make about these cases is, sure, if you drug tested it and you have absolute evidence that you are protecting your skin's own stem cells, then that's not going to be an issue. But the chances are that those claims better be your evidence, your science behind in your labs must, or who the labs you're working with, better be pretty darn strong. So let's go to the next one. The next one is so now these are some FD&C issues, meaning labeling claims or labeling issues. So here is Yes2 Inc., and they sold a product that had actually it was a vitamin C mask, and it caused certain plaintiffs claim that it caused skin irritation. And the claim was that it was around to remediate dull and uneven skin and create even more even looking complexion. Well, that might be true, but if it's true and it's causing irritation, that better be in the product labeling. That, hey, the claim might be like an acid based product, probably from the vitamin C, that is creating a brighter skin type, but it is doing it in a toxic, what these people considered toxic manner. And then they had severe reactions. Well, this isn't necessarily a marketing issue, but it is an issue that you should be aware of when you're creating the marketing content. And in this case, the case is still going on. They haven't pulled the mask yet. So the next one is Pond's Rejuvenous. This is I said smaller, but it's not a small company. But it's the lawsuit is a smaller company. In this case, it's a Proposition 65 and general consumer labeling case. The product contains mercury, and they weren't labeling it that it contained mercury. So looking at those lab tests, looking at what your labs are coming up with, and making sure that your marketing is copacetic to the law. And everyone wants to make claims of effectiveness because that's part of why you're in the market. It is effective in one way or another. And so, but you have to be really aware, and that's the point of today's discussion. Next slide.
Hey, Steve, before we move on to the next topic, in the case of the Yes2 face mask, was that a class action, or is that one individual targeting
no, it's a class
the company?
Class action.
All these the attorneys are I guess, trolling for this kind of feedback and then putting together lawsuits.
Exactly. So class actions are they find you have to find one or more people to certify the class, and then prove that everyone else is going to be damaged and you can't find them. And then you might put a notice up on there's various ways to provide a notice to the class, including demanding customer lists, going down the supply chain, et cetera. And then you provide notice of the claim that you're providing, but you only need one person, and that person usually gets notoriously it's kind of an unfair system. Now they might get $35,000 to be the lead person in the class. So all these are going for really it's hugely for attorney's fees, and the rest would be kind of nuisance value. And then the broadcast of, hey, my product is being sued for a toxic tort is going to kill your brand.
Yeah, it's incredibly damaging. This is such an important topic because I know that the brands and their regulatory department and their product developers, they're thinking about FTC, FDA, and what we're talking about today is just almost the social media universe where you have very little control over what's happening, at you or to you. And you just have to stay so focused on what you truly can say and backing it up with proven science and being really, I think, commanding in it.
Yeah, and keep in mind, in my world, there's no black and white when it comes to what claim. I think that's what the purpose of some of these exercises. There's no black and white on what claim is absolutely going to be a deal killer and what isn't. And if you have the science, well, use the science. I mean, but it takes an evaluation process from the marketing and branding side to say, all right, well, what could be some problems with me making these claims? And I know, listen, we're all customer facing, or in my case, client facing. Is you We all want to make the best case we can why this product's better than the other one, but we have to then sift it through this other lens, which is this going to get me in trouble in the future? And it's hard, and that's why it just has to be. The first thing is to be aware that this is going on, and frankly, I mean, it's getting worse. The next, and we'll hit this slide. Is the next slide is the claims of natural is hugely the next issue. So let's
let's
just go
get to
through
that. Yeah.
Yeah. So the next one, and I'm going to go through a natural one, is the tart ink. I think that's how you pronounce it, which is a false all natural claims. So in this case, you can see the ingredients. Well, I think like citric acid, it certainly can be natural, but they're not. When you look at all these ingredients together, a plaintiff's attorney figured out, and they paid the lab fee or whatever to figure out. Well, a lot of these are lab created and aren't all natural. So the case evaluation right now is 1.7 million. But look at the claims. Look at the claims the company was making. High performance naturals. We believe in high performance and natural. Well, if it's not natural, or an attorney can make a claim that it's not natural, then that's probably not the right marketing message to bring forward. And that's a tough one. Because again, my assumption is that not every brand that I know, not every brand that Jody works with, and not every brand that most of you are working with is a nascent brand. It's not like brand new and you can start from the beginning. You really have to evaluate, well, what claims am I making? And so let's go to the next game. So why were they sued? So here, there's two more games. So let's take a look at what we just learned and figure out, why were these companies sued? So the first one is, here's the hair product claims and what the suits claim. You guys can read the hair product claims. I'll read what the suits claim. So the suit claimed only one, it's A, B, or C. And so this company made the claim. The suit claimed that studies show that biotin and ginseng do not affect hair loss and growth, and that the FTCA considers drugs without proper labels, so that it was not tested to be or labeled to be a drug. So I'll give everyone 2 seconds.
People, yeah. Well, 2 seconds. Wait, we need to read all these bullets. Let's see.
Sure, absolutely.
Okay, let me see what my team is telling me. And by the way, Steve, my team will calculate the winners after the event, and then they'll reach out to the winners on LinkedIn directly for their addresses. So we'll be able to, celebrate our participants that way.
Cool. That sounds great.
Okay, Robin, give me a tally. It's either A, B, or a little trickier, C, all the above. Okay, so we have mostly C's, Steve.
It is
all the above.
Everyone is like, this is going to be quite a competition for this bottle of champagne, because it is C. I would have picked B, because the way that they're claiming it does seem that it's by strengthening each hair strand, protecting. Those are kind of drug claims. But I didn't pick C because how many years in this industry, especially if you get into hair care, have we been claiming that biotin promotes hair growth? And when you go to the drugstore or Costco or whatever, you see biotin in vitamin formulas in the supplements industry. And so biotin, there's definitely a strong link between that and hair growth. And so at least claims of that. So the fact that they were able to sue based on that FDA guidance that biotin doesn't have any link to hair growth really, again, brings pause to what claims you can be making. Because again, I think I've known since I've been like 5 years old that biotin is one of those, you know, especially when I looked at my dad and he was bald, that one of those claims that people have been making. And so you have to be really careful about this because he might not be the next one or you might be. So now I think the next question gets trickier. So we're on question number 4. Why were they sued? So it's a redness solution daily relief cream that contained probiotic and microbiome technology. So this is a tough one. I'll give you guys some time to answer.
Wow, this is a tricky one. We actually do a lot of work in the microbiome space. It's been sort of a slow to start buzzword in our industry, but I see it picking up a lot of momentum. So this is going to be really interesting and very relevant. We also do a lot of work in the hair thinning space too. So you picked really interesting ones for my team to learn from. Okay, let's see what the tallies are for this question. I'll let Carrie or Robin message me.
Well, and the important thing, Jody, is that attorneys do pick up on themes. So this is what's hot to trot. You can see we analyzed 2021, and so these are hot trends on what's hot. But I'm watching a lot of cosmetic lip care, and I think that's going to be another big trend because they're making claims that it has minerals in it and that it puffs up the lips viability. I mean, the whole thing is just that's going to be the next one, I think.
Yeah, I mean, I guess it's so interesting. Like as marketers, we're looking at Google Trends and social listening, and what you're saying is these attorneys are doing the same thing, right? They're following along just like we are.
Trust me, on that one. So, and that's how we learn in industry. That's how we learn what's going on. We just see the same thing over and over, but we have to study the trends. So
okay, so here I have answers for you. Most people, and this is tricky, actually said C, none of the above. They think you're tricking them. Is that true?
No, it's B. So I thought it would be. Let's flip to the next slide. I thought it would be A, because it's like I didn't. It's like I think the trick would be, well, again, a lot of the things we've gone over before are scientific claims, but this is so it's a completely more complicated claim. It's that if it has the if you're making claims of probiotics, it involves live organisms. The preservative, the way I understand this, the preservative they were using, you can't have live organisms, so it's a mislabeling claim. So it's completely like who's going to be harmed by that? No one. But the point is, it still is evolved into a pretty big suit that was filed in March 2021, as in still in litigation. And this is, I mean, we could spend hours on this, but this is a very important marketing claim because what they're saying is you warranted that it had this chemical value, and we did scientific tests, and it just can't be scientifically, and so you breached your warranty to the consumer.
Wow, that's so fascinating because right, the whole premise of the microbiome is these living organisms, and they're saying leverage the power of the microbiome with probiotics, which are living, right? We know that from like yogurt, right? This is really fascinating. I think it will change the way that brands are speaking once the litigation is finalized. Okay, so Steve, we have about 6 minutes left.
Okay, let's keep on keeping through this. So I'm going to
so I want to save like 2 minutes at the end. Sorry, Steve. I just want to save 2 minutes at the end for questions. So if fans have questions, even they're probably going to be questions with long answers, so we can always get back to you on email. But if you have questions for Steve, please submit them now before we run out of time in 5 minutes.
Sure, and one thing is I'm always available to answer questions, talk about your specific product issue. My contact information in the back. So trends, organic is kind of yesterday's news. I think we've all gone through that. The good part about that is the definition of organic is so varied that I think that's a tough claim for a plaintiff's attorney to bring. And the litigation's kind of played out on that. All natural, non-toxic are things that you guys should be aware of. But I think the point Jody's making, and I agree with it, is you have to be aware of what's coming out of your labs or your client's labs. So the next one, you guys, influencers are everything in the 21st century. The problem in your industry is they're going to make claims, and those claims are imputed to you and your clients. So if you're setting up the influencers, they are your agents, and you might be sued for representations they make. That's a heavy burden to bear for you and your industry. And so that involves really managing your influencer and influential relationships. So that is something to really be aware of. So let's get to the last question, because I think we're going to have a tiebreaker here. So this is a fun question. I'm just going to leave it at what it is and see who comes up with what. And then I'll say how I know Jody and who I am, and we'll go from there. And then we'll get to questions.
This is so funny. This is a great tiebreaker, Steve. I wonder if my team who's listening, I wonder if they know the answer. We'll see.
All right.
And,
let's get to
this
it.
is cool. Okay, let me see. I need Carrier Robin to message me and tell me what the most responses are to this last question. Thanks for using a great picture of me too.
Oh, sure. Thank my my brander.
I'm just waiting on responses. One moment. And like I said, put your questions into the tool. We'll hand them off to Steve afterwards so we can answer them, and we can send an email to everybody who attended or post the answers on LinkedIn. And Steve does do something very generous in his practice where he's like always willing to talk to anybody for free for that first call. Right, Steve?
Oh, first there are many calls. We just charge for projects. We're project based. So we want to establish a relationship with our clients and understand their business and their issues. Otherwise, like, again, no one wants to call an attorney and say, well, we might have lead in our product. Then it's like, well, tell me about the product line. You have to learn that stuff. And that should be, we want to build that business relationship. So we don't hesitate to talk to everyone about what their issues are and get to learn their business.
Yeah, I love that. Okay, so most answers were either C or B, Steve.
All right. So A, I think the reason that people didn't pick that is they know Steve looks a lot older than Jody. And they're right. I didn't go to Lafayette College. So that is not the right answer. But I looked up on LinkedIn and noticed Jody did. And I looked up the mascot and I thought that would throw people off. B is L'Occitane is the thing you're going to see in very large brands is that very large brands and very large companies, in this case, a ginormous retailer, first of all, is owned by another company, so that should have thrown you off, based out of France. And they're going to have legacy relationships with attorneys that go back almost centuries. And so the chances of an attorney that is not a legacy attorney of that is going to be, they have I looked up who their trademark attorney is. They've used the same trademark attorney for 58 years. So it wasn't me, and I haven't represented that company. So it's C. I always have an entrepreneurial spirit. I've run companies, and when I exited my last company, I thought about, hey, I just don't see a hair care for balding guys. And I researched who I thought was the best, especially for early stage or growth businesses, and I found Jody. And I didn't know at the time that hair, it was just becoming, the trend was that sun care products were becoming known as toxic, and it was just a really bad time to launch. Plus, I'm an attorney. I'm going to stick with what I know, and that's why I do what I do. And I still think Jody we work on matters together, and I think she's the best. So that's how we know each other.
I love that, Steve. This is such an incredible presentation. Okay, we're at the 1 o'clock mark, but I want to tell our audience, I want to share some of the amazing questions that came in, Steve, and then we'll have you answer them, and we'll post them to LinkedIn, and we'll post them to email. So one of the amazing questions that came in that we'll have Steve work on is, what about perfume brands claiming that essential oils are mood enhancers? So we'll talk about that offline. Another question that came in, so that was from Romney. From Emily, where does responsibility of claims from influencers lie if it isn't a paid partnership? That's an interesting one. So we'll get to that offline. And then, oh, look at that. It's on the screen. That's so cool. Hey, Emily, that's Emily. She's our social media manager. Great question, Emily. And then another question, this one's from Jan. Can marking claims be tempered by adding words such as may help with, or studies have shown, or could help with? So, oh, there's Jan. She's our copywriter. So those are great questions. I know there were many others. So Steve and I will go through them. He'll give us responses. And like you said, if you have a question, reach out to Steve. Let him know that you met him here through this immersion, and he'll get you answers. This was so fun. I mean, I know that there are crazy technical difficulties, but this was like awesome.
Area, and just like wait, it's like kind of, it doesn't require a whole recalibration. It just is like, be aware, be awoke about these issues. A lot of the claims are on the internet. I'm glad to talk to you about them, and really study your brand and how we can get around these claims, because the ultimate goal is to build the most dynamite brand, and then call me about exiting. So that's a scoop.
And it looks like Carrie's calculated our winners. So we'll be able to message our winners over LinkedIn as well. Cool. So I just want to make sure I get it right, Carrie. So I'm not going to say it on air because I'm not really understanding your text. But Steve, thank you for putting up with these technical difficulties. This is such a great topic. And I think you're going to get a lot of questions from my team for sure, building on these ideas. Thank you, everybody.
Have a good one.